Hi everyone, I am honored to be here. My name is Nicole Rhim and I'm a third-year law student, managing editor on Tulane's Maritime Journal. My topic aims to analyze affirmative defenses utilized by shipbuilders in shipbuilding disputes in arbitration and the effectiveness of these defenses. Although the shipbuilding industry is considered one of the most profitable industries around the world, the sector has its obvious downsides. More specifically, the current global economic and political crisis is producing strained financial conditions for the shipbuilding sector, resulting in an increase in lawsuits. For my information and conclusions, I specifically examined affirmative defenses utilized by shipbuilders in the British and Irish Legal Information Institute and other anonymous arbitration reports to conclude the weaknesses and strengths of these defenses. So a general overview of the shipbuilding industry. The shipbuilding industry is currently dominated by South Korea, Japan, and China in both commercial and naval segments. Japan and South Korea were once former global industry leaders, but China overtook this role due to its reputation as a low-cost, high-volume shipbuilder. Chinese yards, or shipbuilders, are generally divided into two conglomerates: China State Shipbuilding Industry, or China Shipbuilding Industry Corporation. All large yards are associated with either of these conglomerates. The shipbuilding industry, as I previously alluded to, is a cyclical industry. Shipbuilders scramble to meet demand when the economy is healthy and trade healthy and booming. Once production needs are met, demand decreases, exuberating a collapse in shipping prices and causing shipbuilders to scale back and eventually go out of business. Then the process repeats itself again when the economy is healthy. The ups and downs of the market also dictate when contracts are canceled and when buyers pursue litigation. When the market is on the rise, shipbuilders have the bargaining power to control the contract's terms as buyers compete for berth space. Shipbuilders and buyers hardly dispute contracts, and fewer are canceled if the demand is greater than supply. Whereas when the market is suffering, buyers gain contractual bargaining power and cancel contracts for the slightest delays on delivery dates. The traditional means for resolving shipbuilding contract disputes is through arbitration rather than litigation. With Chinese yards at the forefront of these disputes, it would be presumed that the parties would agree to the CMAC or Chinese law. However, most shipyard contract disputes are decided by the London Maritime Arbitrators Association, the LMAA, or under English law. Foreign consumers generally require the law of a non-partisan jurisdiction and a non-partisan dispute resolution if a shipbuilding contract is breached. Therefore, a substantial majority of these international shipbuilding contracts are governed under English law and make reference to English arbitration, whether or not explicit to the LMAA. The following are some arguments brought to the court or to arbitration. During negotiation stages, shipbuilders will often protect themselves with clauses for events that are outside of their control. Shipbuilding contracts will provide that the delivery date may be postponed if a certain event occurs. This is also known as a force majeure event. Even with explicit force majeure events in contracts, however, the general trend in recent court and arbitration decisions is to disfavor the shipbuilder and instead favor the buyer. For example, in Adyard Abu Dhabi versus SD Marine Services, the commercial court held for the buyers, concluding that a failure to give force majeure notices disqualified the shipbuilder from claiming an extension to the delivery date to which they would have otherwise been entitled to. The court had ruled that the event was outside of the builder's control and that this met the contract's definition of a force majeure event. However, the court noted that even if this is a force majeure event, the notice of the event is essential. Moreover, the court reasoned that the yard had to prove causation between the extension of time and the event. Another example is found in an anonymous arbitration report where London arbitrators held that a shipbuilder could not rely on a force majeure event. The shipbuilder claimed that a force majeure event occurred, that the builder had failed to timely approve construction drawings for the shipbuilding process. However, the arbitrators reasoned that if this claim were validated, it would produce uncommercial and unworkable results. Moreover, the arbitrators emphasized that the shipbuilder should notify the buyer immediately rather than later in the process about a delay. For future proceedings, the builder needs to further supplement this claim by proof that there is a nexus between the force majeure event and the delay in the shipbuilding process. Moreover, where the contract specifies a notice of an outlined force majeure event, builders should communicate with buyers if this event occurs to protect themselves against rescinded contracts. Another common defense is when there are delays in payment installments. Although the buyer's obligations are limited in a shipbuilding contract, one primary obligation is to pay the purchase price. Generally, the buyer pays for the price of the ship in installments. Installments are paid for when either a milestone is met or when a date occurs. If not paid for, the buyer's payments will likely be secured by a refund guarantee. Despite this guarantee, problems arise concerning what triggers the obligation to pay and when these payments are received. More and more shipbuilders argue that when a buyer fails to pay these installments, it creates a delay in the shipbuilding process. Thus, the buyer has no grounds to cancel the contract, and the shipbuilder may satisfy the costs incurred from the construction process with the refund guarantee. Based off several arbitration proceedings, builders can succeed in arbitration if the buyer fails to pay these payments in the installment process. The builder and buyer must remain wary in how they specify the agreement, however. Parties in these types of contracts should try to schedule payments to accurately reflect the work performed to date. To prevent these types of disputes from causing delays, buyer and builder need to factor in the type of ship being built and the costs associated with it during the negotiation stages. Moreover, it may be useful to appoint a third party, such as a marine surveyor, to have the binding authority to conclude whether a milestone has occurred. In addition, the refund guarantee needs to be worded with extreme caution on both sides. If the buyer agrees to an extension of the refund guarantee, the builder is advised to make the refund guarantee a condition precedent to the continued existence of the contract or set a deadline for the extension itself. On the other hand, the buyer should carefully set out the procedures in relation to calling on the refund guarantee and establish who has the authority to sign on the bank's behalf. In conclusion, hopefully arbitration proceedings and courts can establish some form of consistency when approaching these types of arguments and how parties can prepare for these cases. This will most likely provide just and certain results in the process, but more importantly, to prevent these proceedings from happening in the first place. Both the builder and buyer need to establish rapport and a clear understanding of what responsibilities are undertaken by the other. Although arbitrators will likely still deal with shipbuilding disputes regardless of a seemingly perfect contract, a detailed and clear contract can help prevent delays in the shipbuilding process and help achieve both parties' goals.